Please, Your Lordship, I beg to mention item number 1. Your Lordship, let this matter come next week.
Next week. 23.
Yes, Your Lordship.
On premier by the appellant, place this matter after 3 weeks.
3 weeks.
Anyone who asks for adjournment, I'll use my discretion whether to give you less time or more time.
Absolutely, my lord.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 3, Your Lordship. Lordship, the County Council, Mr. Pupin is indisposed, Your Lordship. We have already taken the consents of the state, Your Lordship.
2020 matter.
Yes, Your Lordship.
On premier by the petitioner, place this matter to 2 weeks.
Lordship, Lordship.
So, from supplementary cause list, item number 1.
This is the bill. The respondent were supposed to.
Oh, he is to get the
Yes.
CD.
Yes, Your Lordship.
He's not here. Pass over.
Item number 2. From daily list, item number 2.
Same matter.
Yes.
Item
This is from daily list.
Daily list, not supply.
1 and 2 are, same. Isn't it?
There's a reply.
So we are hearing on the impleachment petition.
Yes, Lordship. Lordship, wide annexure 4 of my petition, Lordship, an order was passed to delete the name of respondent number 1, struck off the respondent number 1 as no legal heirs or representative
Just
as
a moment.
respondent,
Just a moment.
as per order dated.
Just a moment. This is Miss Case. This application 4. Yes, miss, you're referring to?
Yes, annexure 4, Lordship, page 25.
Yes.
May I read, Lordship? Mr. K. Paul Lannis Senior, for the petitioner, has submitted that the respondent number 1 is since deceased, and in fact no relief is sought for as far as the respondent number 1 is concerned, and therefore the petitioner would refrain from taking steps for substitution or otherwise, as the right to sue does not survive. Being the case, it is prayed that the time for the respondent number 1 be the name of respondent number 1 be struck off from the array of parties herein. Lordship, now since the legal heir of respondent number 1 has not come forward after the death of respondent number 1, Lordship, the communication between the legal heir of respondent number 1 and the counsel was stopped. So since the petitioner knew that the respondent number 1 has expired, it was the petitioner who would have brought the legal heirs into as an array of parties. Now, since this is my impleadment petition, Lordship, the grandson of respondent number 1, because the son has also expired in this case, who was in touch with the councils. So son also expired. So the grandson has come up as a legal heir, Your Lordship, and he wants to get himself impleaded, Lordship. So that is why my this application is, and I have obtained NOC from the wife of the son, and also the wife of the sons who expired, and also the daughter who is the surviving legal heir of respondent number 1. So my humble prayer is that I may be impleaded, because I have already obtained NOC, and it is a family, since it is a family dispute, Lordship. It is a landed property dispute. My rights over the landed property would get refrained if I am not being impleaded, Lordship. That is why, Lordship, this application is.
What are your legal grounds?
Lordship, being the legal heir, Lordship.
What is the relevant provision here?
I have.
CPC would be your guide.
Yes, Lordship.
What does CPC say as far as
CPC Order 1 Rule 10(2) of the CPC, Lordship. Rule 10(2).
Just one.
Lordship.
Yes, what does it say?
Court may strike out or add parties, Lordship. The court may at any stage of the proceeding, either upon or without the application of either party, and on such terms as may appear to the court be just, order that the name of any party improperly joined, whether as a plaintiff or defendant, be struck off, and that the name of any person who ought to have been joined, whether as a plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. So, Lordship, here, since I am a necessary party as a defendant, Lordship, I would like to add as a party. And here it is also mentioned that the court can take suo motu.
This speaks of addition or deletion of party.
Yes,
who
Lordship.
are who are presently in the suit or in the matter.
Lordship,
Now,
yes.
What is the specific provision where it says on the death of either the plaintiff or the defendant, substitution of the legal heirs has to be made, or they have to be brought into court, and in what manner that has to be done? Where is it? There must be a provision here.
Lordship, yes, Lordship, substitution provision is there, but Lordship, now first, since I have filed this petition as an impleadment of parties and not as a substitution of parties, Lordship, I filed
not for substitution of the deceased defendant.
Lordship, deceased defendant, Lordship, but for this petition is about the impediment of parties, Lordship. So I have come under this provision. The substitution provision is there, Lordship. Lordship,
Your impediment must have some basis.
Lordship,
The basis apparently is on the fact that the sole respondent is deceased.
disease, Lordship.
Not the sole respondent, rather the respondent one is deceased.
Yes, Lordship.
So as the legal heir, you have come into the picture.
Lordship.
There must be the proper way of how to go about it. So you
Lordship.
tell me from the provision of the law, what is that?
Lordship, substitution petition, it is the provision of substitution petition is there, Lordship. Lordship, Order 22.
Rule?
Under Order 22, Lordship.
Yes, order 22 now.
Yes, Lordship. Order 22, Rule 4, Lordship. Procedure in case of death of one of several defendants or of sole defendant, Lordship. Lordship, may I read, Lordship?
Yes.
When one of two or more defendants dies and the right to sue does not survive against the surviving defendants or the defendants alone, or a sole defendant or sole surviving defendant dies and the right to sue survives, the court on application made in that behalf shall cause the legal representatives of the deceased defendant to be made a party and shall proceed with the suit. So here, Lordship, the provision is there, Lordship, if the defendants expired, then the legal representative can come forward on behalf of an application made. The court can substitute the legal representative, Lordship. Lordship, now wherein within the Rule 4, now 3, Lordship, I am coming to 3, which is relevant in my case, Lordship, where within the time limit by law, no application is made under Subrule 1, the suit shall abate as against the deceased defendant. The court, whenever it thinks fit, may exempt the plaintiff from the necessity to substitute the legal representative of any such defendant who has failed to file written statement or who having failed it has failed to appear and contest the suit at hearing. The judgment may in such case be pronounced against the said defendant notwithstanding the death of such defendant, and shall have the same force and effect as if it has been pronounced before death took place. So in this case, my situation arose as clause 4, Lordship, wherein the court has abated that being that since there is no legal representative. But it is also the case that if anyone comes forward with a proper application, Lordship, then the court may consider that to substitute that person as a legal representative, Lordship. Now in this case, Lordship, I have a but I have not xeroxed. Lordship, in Supreme Court judgment, Puran Singh and another, Lordship,
What is the citation?
Lordship, here the AIR SC 1092.
EIR?
AIR SC 1092.
Be a year, no? There have to be a year.
Yeah, here.
Yes, I am giving 1996.
Yes.
In that case, Lordship, here
Para?
para 11, Lordship, it is stated that as such, even if it is held that order 22 of the code is not applicable to proceedings or writ appeals, it does not mean that the petitioner or the appellant in such writ petitions or writ appeal can ignore the death of the respondent. If the right to pursue remedy even after death of the respondent survives. After the death of the respondent, it is incumbent on the parties of the petitioner or the appellant to substitute the I may stress on, it is incumbent on the party of the petitioner or the appellant to substitute the heirs of such respondent within a reasonable time. So it is also incumbent on the petitioner or the appellant to substitute the defendant, Lordship. Lordship, I'll supply the copy, Lordship, after sometimes, Lordship. So I am relying on this judgment, Lordship, and as such I am praying that I may be implemented, Lordship, being the legal heir, Lordship.
So that's it.
That's it, Lordship.
Yes, Mr. Port.
I'll first take your lordships to the prayer made in the application here before your lordships.
Yes.
At page 5. It says, in the premises of faucet, it is most humbly prayed that your lordships may be pleased to admit this petition and may be pleased to plead the applicant as a necessary party in the array of parties in the instant case, and further be pleased to vacate the order dated 25/7/2023 to enable the applicant to enter into the case as the legal heir of Prabhashini Datta. The two aspects here, Milad. One, that I'll first take your lordships to that order, Milad. That order is also annexed by my learned friend at page 25, your lordship. This is the order that they're seeking vacation of.
Yes.
Your lordships have it. The third paragraph. This court, on consideration of the submission made, prima facie would allow the prayer made by the petitioner, and since the legal heirs or representative of the respondent number 1 are not required to be substituted in these proceedings, the name of the respondent number 1 is hereby struck off from these proceedings. The matter will now proceed in its usual course. The lordships would recollect, we had taken our lordships through the merits of the matter. That the order under challenge before lordships is an order passed by the revenue board, whereby, my lords, there was some recommendation insofar as cancellation of my lease was concerned. There is no parallel finding in favor of the respondent number 1 at that point of time, or the grandmother of the present applicant. So we had submitted to the lordships that insofar as respondent number 1 is concerned, my lord, she was only a formal party during the proceedings because she had initiated the proceedings. So there is no substantive right created on her by virtue of the order. As such, the right to sue does not survive. Be that as it may. Now, if we come back to this order, my lords, that has been the application which has been filed, my lords, I can understand that there are two prayers that the applicant is making. he seeks vacation of that order. If he seeks vacation of that order, my lords, my humble submission is he would have to substantiate before your lordships as to why that order should be vacated. I can see the pleadings, my lords, here before your lordships, and your lordships have already seen it, except for, my lords, in para 3, 4, 5 and 6, narrating the family tree of the deceased respondent number 1. There is no averment before your lordships as to how the rights of the present petitioner are actually, or why the petitioner is aggrieved by the order passed by your lordships, deleting the name of respondent number 1. In the absence of that averment, my lords, there is no reason your lordships would interfere and vacate an order. If I come before your lordships, my lords, I would first have to demonstrate that I am aggrieved by an order. This is the legal vested right that was there on me. Through oversight or otherwise, my lords, my right has been infringed, and I come before your lordships as if kindly vacate that order, recall that order rather, my lords, and, my lords, allow me to participate in the proceedings. That would be one aspect of the matter. But my learned friend says that this is not an application seeking substitution. So she doesn't want to step into the shoes of respondent number 1. And as your lordships had rightly, my lord, made a query, what is the provision? Then it would have to be under Order 22, Rule 4. I'll come to that aspect of the matter. Now the second part is, she wants to be impleted. Now I'll take your lordship to Order 1, Rule 10. Your lordships have noticed.
Yes.
Order 1, Rule 10 2. Court may strike out or add parties. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court to effectually and completely to adjudicate upon the settle all questions involved of the suit be added. This would have to be read in the face of the order passed by your lordships on the 25th. Admittedly, my lords, the petitioner claims that I am the legal heir of Prabhashini Datta, so therefore my right. So at the time, my lords, when the suit was initiated or instituted or otherwise, he was not a proper party. If at all, my lords, he becomes a proper party today, he would be drawing his title from respondent number 1. So he cannot have an independent cause under Order 1, Rule 10.2 that I have to be impleted as a party because of this reason, and therefore, my lords, my application under Order 1, Rule 10. And your lordships would also not exercise that power, my lord, suo motu, because there's no question of the present applicant being a proper party or a necessary party at any stage. If at all, my lords, and this is only for the sake of argument, I'm not conceding, if at all any right to sue survives, insofar as the applicant is concerned, my lords, it is under the title of respondent number 1, which is his admitted case before your lordships. So there's no question of filing an application under Order 1, Rule 10. If at all, my lords, they would have to satisfy your lordships what legal right has been injured by virtue of the name of respondent number 1 being struck off, for your lordships to recall that order, and thereafter, my lords, file an application seeking substitution. To my mind, my lords, why this application under Order 1, Rule 10 has come is because under Order 22, your lordships have seen that the law also prescribes a limitation from the date of death. Admittedly, my lords, the uncle of the applicant, who is the son, who they say in the application was following the proceedings and was very much alive, was conscious of the orders passed by this Honorable Court recording that Prabhashini Datta is dead. There was a requirement in law, my lords, for him to file an application bringing on record the list of legal heirs.
The son of the original respondent is
He is
still alive.
also
He's
dead
deceased.
now, my lords. Lordships would recollect some applications had been filed, some counsels engaged, then it turned out, my lords, it was signed by somebody else. There's a lot of confusion. He chose not to do that. So, insofar as this matter is concerned, my lords, insofar as respondent number one's representation before this proceedings are concerned, they were conscious all along and they chose to sit on it. Now, after sitting on it, my lords, the date of death of the respondent number one is very interesting. She expired on 22/2/2019.
Okay.
The son, my lords, who is allegedly pursuing the entire matter, who had also filed some applications before your lordships, was one late Bishwanath Datta. He expires on 13/1/2024. So for 5 years, he was actually pursuing this matter, even without filing any proper application, no proper representation. So he was conscious of that fact. Now, my lords, to bypass the provision of 90 days, Order 22, Rule 4, my lords, Sub-Rule 3, your lordships have seen, that the limitation applies, my lords, and there is a 90-day period after which it abates. Now, to bypass the entire thing, we come with an application under Order 1, Rule 10, saying that I have to be implemented as a party. The first thing is, my lords, they have to establish some substantive right, which my humble understanding of the application, it is absolutely silent. It does not say what substantive right has been infringed. They would have to establish before your lordships, this is my right, this is by virtue of the orders passed by your lordships, my lords, this is what has been infringed, and this is the law, and therefore, my lords, I need to be substituted in place of respondent number one, and my lords, they would have to get across the legal embargo of limitation. Besides the fact, my lords, if your lordships would, I'm sure my learned friend remembers, last time another application with same prayer was filed before your lordships, which was subsequently withdrawn by my learned friend. And, my lords, in the course of the hearing, it had also fallen from this honorable court that insofar as these proceedings are concerned, my lords, there is nothing insofar as respondent number one is concerned. If anything, it would have to go back before the concerned court. Because here your lordships are only deciding the legality or illegality of the orders passed by the revenue board. The substantive issue, my lords, would continue to be before the, not even before the revenue board, it would be before the deputy commissioner. So if at all, my lords, they feel that some right survives, they would have to go and impress upon the deputy commissioner that yes, I step into the shoes of the complainant and the complaint survives.
But you see, under the circumstances,
My lords.
suppose,
My lords.
hypothetically, the appeal order is set aside.
My lords.
Matter is remanded to the deputy commissioner.
My lords.
There would be a necessary party. This the legal heir of the.
Well, it's if the right to sue survives.
If the right to sue survives.
Why I'd say, my lords, it does
What
not survive
happens
is...
is, can substitution be done at that point of time?
Can, my lords. They would have
would
to
it be a
satisfy the
continuation-
court there.
Would it be a continuation of the proceedings herein?
No, my lords. In my humble submission, no. Because the substance of the complaint, I read the complaint on the last occasion, if your lordships would recollect. The substance of the complaint is that I have a limited right over that property. The case of respondent number one. She herself claims, my lord, she has a limited right over the property.
In what sense?
Well, I'll just take your lordships. She says, my lord, she had purchased it for my grandfather post 1972. And she says, my lords, that therefore I have a right of that property. Post 1972, my lords, any kind of purchase by a non-tribal will be otherwise hit by Section 3 of the Land Transfer Regulation Act.
Unless the concession is given
By the state government. Admittedly, there is no concession. So then, my lords, the remedy, I'm not to advise, the remedy will lie elsewhere. Remedy would be before an appropriate civil court. So what is happening is, my lords, we're going round and round and round and round. That is why I had submitted before your lordships. We can try and put a quietus to this entire matter. Because it is, before your lordships, the challenge is on a core legal issue. Whether, my lords, under the land regulations, the deputy commissioner has the power or the commissioner has the power. And the Meghalaya interpretation of statutes is very specific, my lords. It says it is the commissioner of the sub-division, commissioner of the division, not the deputy commissioner. So that is the only limited issue that your lordships will decide.
See, Mr. Barsarji, what Mr. Paul said is also correct. You have to establish your right. You have to establish your bona fide as to how the impugned order would affect you. Now you say, now the original respondent, defendant, petitioner, whatever the case may be, is deceased.
Deceased.
The immediate legal heir would be her children.
Children.
We don't know whether she has only one son or two sons or.
She had two sons.
Well,
Both
that
of
is
them
a-
expired.
That is again interesting, Balaj, because all along in that earlier show cause file, it was all along projected before Lordships that there is only one heir.
Oh.
I have not even gone into that aspect because I cannot at this stage.
No,
Then I would have to question 50 other things.
we are looking at the bigger picture here.
Lordship.
Now, if that is the case, so the legal heir, who is the direct descendant of the deceased,
Lordship.
would come into the picture. You say one son is deceased. Now you say there's another son. Is he still alive or is he deceased?
He is also deceased, Balaj.
Two sons deceased. One daughter is alive, but daughter is not in a position, medically not fit to come. She stays in Jorhat, so she is not medically fit. And Lordship, I have in my application also I have stated that the grandson is
How many grandsons are there? How many
Now-
granddaughters are there?
Lordship.
From the two sons and the daughter.
Lordship, the granddaughters are 1,
8
2.
grandchildren, Balaj.
8 grandchildren.
Yes, Lordship.
So
Out of that, one of them is before your Lordship.
Lordship, I have already.
whether he has he has been authorized by.
Yes, Lordship. The NOCs are there, Lordship, in the annexures. I have already enclosed.
Here in this petition.
Yes, Lordship.
What in
The power of attorney is there, Lordship.
power of attorney? Where is
Yes,
it?
Lordship. Power of attorney, page number 40, 41.
There is only one person.
Lordship,
This only one person.
36, 37. Lordship,
This is I think the daughter.
yes, Lordship.
Daughter-in-law, Balaj.
From page 28 onwards, all the power of attorneys are there, Lordship.
That is again going to create another problem for my learned friend, Malaj, because the agent cannot have a better title than the principal. Applications would have to be by the principal, represented by the attorney holder.
Lordship, now also the case is that, Lordship, if I am not implicated in this case, Lordship, since my grandmother's name is already deleted, in my prayer I have also reflected, Lordship, being the legal heir of my late deceased grandmother, I may be allowed to implead. So my right to sue remains, Lordship. Now, if in this case, Lordship, I am not being impleaded, then here also one aspect is also there, Lordship. If the plaintiff is well aware that there is a death of the defendant, the plaintiff also needs to take steps. So here the plaintiff also did not.
Is silent. Or
Is
did not take
is
any
totally
step.
silent.
Anyway,
He's
that
here.
aspect will be looked into.
So,
Balaj,
Lordship, here
if I may just
the
interject here for a second. The plaintiff here is my learned friend.
plaintiff
Your
or
Lordships-
appellant? Appellant
Yeah.
is
Your lordships are not an appeal.
Yeah.
I am conscious of that fact. Lordships are in revision.
Revision.
So therefore, my lords, insofar as Order 22 is concerned, the duty would have to be discharged by the applicant or the predecessors of the applicant.
Lordship.
I am aware, my lords, if I had been the plaintiff, then the rights, my lords, the duties under Order 22 would have to be discharged by me.
Okay.
Lordship, the judgment where it is what I have mentioned, it's with regard to writ petition, Lordship. It is not saying that, according to the according to the Rule 22, it is saying that plaintiff defendant. But in writ appeal also it is said that the same procedure applies.
Same procedure apply, but in as far as writ jurisdiction is concerned, the letter of the CPC or CRPC is not taken. You see, is not taken in toto. It's the spirit that would apply. Well, see, the court more or less would go with what is the relevant provision.
Lordship.
But in your case, there are so many contradictions, there are so many hurdles that you have to overcome. To enable
Lordship,
this court to come to a clear understanding of your case.
Lordship, if I am not substituted here, Lordship, if I go back again to the revenue court, Lordship, it will be a Lordship, there will be much, because there will be the proceedings will be initiated from, the proceeding will start from the scratching level, Lordship, where, or the continuation of the previous proceedings, Lordship. So the gap has to be condoned by this court, Lordship, that this is since the matter was here in the middle, the matter has come up after the order and judgment was passed by the revenue court, the matter has come up here. So the gap is condoned by this court. So Lordship, if I am not impleaded here, Lordship, if I go back, my right would get infringed, Lordship. Because there again, since I am not party, the appellant will take that since they were not the party therein, they cannot step in here. So my right will get definitely infringed because here my right has I need to get impleaded here, Lordship. Unless and I get impleaded here, there my right gets
Extinguished, you say?
extinguished or abated. So, Lordship, I need to be impleaded in this case, Lordship.
Other thing, of course, is, well, I think my learned friend would have to satisfy. I don't want to catch her by surprise. The power of attorney is in respect of only 4 people out of the total number of, I don't know, 13.
But the Lordship here also,
I don't know, she will have to satisfy your Lordship regarding that also.
Yes,
If
Lordship.
she says she's an attorney holder of everybody.
Lordship, that is what
if I may just finish, then you can respond.
Lordship. Yes, yes.
I don't want to be let it be in piecemeal knowledge. The other is the applicant is one Mr. Antariksh Kalita. All the legal heirs are not applicants.
Exactly.
If at all, well, it's an applicant, if what my learned friend is espousing that they have to come in and be impleaded and not substituted, I'm saying, well, they cannot be impleaded. If at all, they have to be substituted. There's no application for substitution. Then all of them would have to be there. Could probably be represented by one person before launch. That's a different issue. The Power of Attorneys Act is very specific. The attorney cannot, the agent cannot have a better title than the principal. Here the agent is, well, it's espousing before your lordships a case for himself, not on behalf of his principals. He's treating that as a no objection. That cannot be a no objection. They would have to come before your lordships, fellows, and say that, okay, insofar as I am concerned, I do not want to espouse this matter. Let it go to so and so. That would have been a different case. These are power of attorneys. And the language of the power of attorneys also, your lordships will kindly have a look at it. I didn't want to get into this, but since my learned friend is insisting. Page 42, Melons, I'll very just quickly just take one. It's a standard general power of attorney.
Page?
42, Melons.
42.
That is the relevant provision which my learned friend would have to rely so far as representation before this court is concerned. To represent me for and on my behalf before any government, semi-government, quasi-government, statutory authority, municipality, and before any court of law. Where is this person before this court? The principal here, Melons, is one Silbina Kharbangar, but so she's not an applicant before your lordships. So if at all, Melons, she has to be here before your lordships. Who is here before your lordships? The affidavit of the applicant, let's go back to the affidavit of the applicant, Melons. Page 6. The affidavit, Melons, may kindly have a look.
Yes.
Paragraph 1, Melons, that I am are the applicant in the instant application, well conversant with the facts of the case, and I am as such competent to so and so. Prayer is, my lords, to implead the applicant at page 5. In that event, my lords, he would also have to demonstrate that he has better title than the rest of the legal heirs.
That was the initial query that was made to you as to how he can be singled out to represent the cause of the original party that is the deceased.
Lordship, on oath I am saying that I am the grandson of the, while filing this application.
You are not the only grandson.
Lordship.
You may be the grandson. Well, we will accept that. But you are
Lordship.
not the only grandson. Now, you, by your own admission, you have listed a number of legal heirs,
Lordship.
13 of them.
Lordship.
As Mr. Paul said, I believe that would be the correct proposition of law, that they would first have to stand in place of the deceased. Thereafter, they hand over their authority to the applicant herein, as their representative or power of attorney holder. That you see, that procedure has not been
Lordship,
followed.
then also my learned senior's application has to also come forward, Lordship. Here the Lordship, the application, he has to file a proper application substituting the legal heirs, Lordship. There is no application from his side also, Lordship. He needed to file a proper application before this honorable court stating that since the defendant deceased, Lordship, so the legal heir should be impleaded, Lordship. He has never come forward before this honorable court.
Yes, anything else, Mr. Paul?
I think, well, it's
What you see, what you can do, I think you just reduce your argument in the written form. Try to find out authority for each points that you are raising, each contention that you are presenting. That will be easier for the court. There's you see, as far as civil matters are concerned, there's so much of complication because it overlaps.
Lordship.
So I will not be able to complain as to what would relate to Order 22, what would relate to Order 10.
if your lordships permit, may I pray that your lordships, my learned friend, let her go back and do some research, Mills. I'll also do some research. As your lordships have rightly said, Mills, civil law is so overlapping. My learned friend's prayer here is for impleadment and not for substitution. So an application for impleadment will lie and not for substitution, my lords. My learned friend would have to satisfy your lordships on that. That it would be Order 1, Rule 10.2 and not Order 22, Rule 4. If that aspect is settled, my lords, then I think your lordships, we can get into the next step.
True.
And of course, my lords, with modification, vacation of the order, the authorities are there, I can place it.
That of course you see that.
Under what circumstances, my lords, I can come before your lordships and seek a recall. Recall would be equivalent to review, my lords. I'll have to demonstrate before your lordships that this.
Yes.
These are the parameters.
You see,
Let my friend satisfy your lordships on
if
that.
there are errors of facts or or law, but then that apart, what Mr. Paul said is also correct. You first have to compartmentalize your contention as far as impleadment is concerned. Then you go to the next table, that is substitution,
Lordship.
and see how they fit in. Because now you've come for impleadment.
Lordship.
If you've come for impleadment, Order 10 would apply to you if the court is satisfied that you are a proper and necessary party who ought to be in the proceedings. So that makes you a stranger. That makes you a stranger, not related to the deceased at all, which is also permissible if you can satisfy this court or convince this court otherwise. But then, if you say now you have come, in substitution of the deceased, then what is the path you have taken to reach there? Please just clarify on that.
Lordship.
Mr. Paul, you also do the same. as far as your part is concerned, whether it's incumbent upon you to take steps as far as the legal heirs are concerned.
I'll do that.
2 weeks.
Lordship.
Having heard the parties to a certain extent, prayer is made for this matter to be adjourned so as to enable the parties to seek instruction as to how to proceed with this matter. As prayed for, this is matter after 2 weeks.
2 weeks. Today.
Item number 4.
Excuse me.
May it please your Lordship. Lordship, I humbly pray if this matter may be adjourned today, your Lordship, as the senior conducting counsel, Dr. Muzik, is on legs before court number 2, your Lordship.
Yes, Lordship, then it may be after 2 weeks, Lordship, because next week I may go for tooth extraction.
On prayer made by the respondent, not objected to by petitioner, this is matter after 2 weeks.
Second call from supplementary cost list, item number 1.
Your Lordship, I humbly pray if this matter may be taken up on Monday, your Lordship, as we're still awaiting instructions, your Lordship.
So, sufficient opportunity has been provided, your Lordship. They are not coming up.
Actually, you just, you could have also done it. Get instruction. And
Yes, your Lordship.
what you have to do is you just have to contact the IO
Yes, your Lordship.
and get the detailed, report. This because, as I've stated earlier,
Yes, your Lordship.
what this court would like to know or find out is the nexus of the petitioner with the so-called kingpin, if you put it that way, because he has never been caught.
Never been caught. From his position also nothing was recovered.
No, I'm talking about the because you see one name has come up,
Yes, Lordship.
who is said to be the
Kingpin.
kingpin who has arranged the transaction.
Yes.
So if he has done it through some other,
If-
not connected to you, perhaps a different view could be taken.
Yes.
But then, if there has been communication with you prior to the transaction,
Yes.
then so that is what is required, because you have listed. In fact, he has annexed a copy of those
Final complaint.
the final complaint. Reference was made to the CDR.
But CDR has not been filed before
But
the
that
trial
exactly-
court.
Because in the CDR you will find if I recall correctly, mobile phone number, so and so made a call to this number at such and such time. So we just find out who are the the owner or the one who holds this phone. That's the only thing. But that has been made clear to you. You could have done that.
And my lord, in
Nowadays, this is not difficult. Even if the IO is somewhere else, he could just mail it to you, WhatsApp it to you. It is not that is required for the record. It's just for perusal of this court.
my lord, in the charge sheet they have not enclosed that also. So even if they will produce now, your lordship, it will be an afterthought, because in the case record it is not there, and there is different procedure for bringing on record also,
Yeah,
that
that
also.
was-
So they have not done, and it amounts to extension of time, your lordship, because investigation stage already over.
Certificate under 65.
Yes, so it that also has to be considered, because this is not the time stage of investigation. They have filed the final complaint. They cannot bring. They can bring either through supplementary charge sheet or something like this. But at this, before this honorable court, as of now, there is nothing. So your lordship.
See, Mr.
Yes.
Pandit, there may be nothing.
Yes.
Now we are dealing only with bail.
Yes, your lordship.
this court is not going to the merits of the
Depth,
trial.
yes, yes,
At the trial, you can raise all those issues.
yes.
Even you
Yeah.
see, even if there is
Slightest.
even if there is a
Slightest,
a statement recorded under 161,
Yes,
even if it links to you,
yes,
the court would presume prima facie that you are involved. Of course, it would depend on in course of proceedings,
yes,
in course of the trial,
yes,
to prove you are innocent.
yes,
So as far as bail is concerned, the court need not go into all those.
yes.
So now it's up to you. Yes, Dr. Muzika, you.
But there's nothing more beyond that,
colleague was
madam.
trying her best to escape.
No, madam, this is not matter. Item number 17 was going on.
Certainly.
So, my lord, there's nothing more beyond that, my lord. The charge sheet I pointed out on the last occasion, my lord.
So you would concede that
I don't concede, my lord.
no,
My lord.
as far as bail is concerned, you see, then the court would give them the benefit of the doubt at this point of time.
I'll leave it to lots of discussion.
That would be because if they are truly or innocent, then, or even if they're guilty and they belong to that 99 class, you know that, no? Let 99 guilty be set free. One innocent,
innocent is
not to be.
Should not be. That's what we are following, my lord. Our conviction rate is 2%, 1%.
Conviction rate, of course, that depends. But you notice conviction rate now has gone up,
Now it's gone up.
especially in POCSO matters. Because now the law is
So, law of evidence is totally screwed, my lord. If victim says, my lord, that is like
also is very difficult.
impossible to demolish that. My lord.
true. That's what the law. So the only guidance or rather direction that the high courts or the low courts would have is only if there's a a proper order comes from the Supreme
Yes.
Court, giving the guidelines
My lord.
and laying down the law. Otherwise, we have to go by what is on record, what is apparent.
POCSO case is very difficult, Your Lordship.
Anyway, I'll go to the
My lord.
petition. I'll pass the orders.
My lord.